Hey everybody, this is Charles Langevin. I'm the executive director of Georgia Parents for Kids' Rights. Um, Today we're going to talk to a little bit about divorce, child custody, and child support. That would include legitimation and stuff like that. My partner is with me tonight. She had a family emergency, so what we're going to do is I'm going to ask you guys to post any questions you have in the comment section. That way, I'm not standing here looking at the screen, just talking, going on and on and on. So I hope that you guys can get some value out of this, get a little bit of insight as far as how courts work and how things are going to play out if you're going through some kind of a case that involves your children, specifically in a divorce or a breakup of some sort. So post the things down at the bottom. If you think anybody is in a position to where they need some of this information, share it to them, send them a link to it, do whatever it takes to get the word out here. We are trying to make sure that all the children of the state of Georgia and really around the nation have the benefit of having both parents in their lives, and we don't have this really hard fought custody battle. Um, so first, I'm going to start out with Georgia Parents for Kids' Rights. We are a 501c4 organization here in Georgia. And what happens with what we're trying to do is we're trying to ensure that this conflict that occurs where people want to fight with their ex and stuff like that, it's very detrimental to children. So our goal is to make it to where that won't happen anymore, or at least it'll be less so than it currently is. Um, so we are currently working on legislation that would presume that both parents are to be treated as equals in child custody cases until one of the parents is proven to be unfit. In most cases, that is not going to be the case. Or in some cases, unwillingness is not something, if you're not, if I live in Florida and you live in Alaska, it's probably not going to be 50-50, but the person should be able to get as much parenting time as possible. So today we're going to talk about divorce, legitimation, child support, any kind of modifications to child support, child custody, which tends to be the divorce and legitimation after the fact. And then also co-parenting and parallel parenting. That's a very important thing for us to learn because once we have a child with somebody, we basically we're in a position to where we're going to have to live with that person for 18 years at least. So that's something that we have to be able to do. The thing that I do have to disclose here is I am not an attorney. We don't have attorneys at Georgia Parents for Kids' Rights. We do work with a lot of attorneys, but nothing that I say today should be construed or relied upon as legal advice. If you need legal advice, you need to reach out to an attorney in your area, in your state, and they're the only ones that are legally allowed to provide legal advice. So let's kind of start by talking about the difference between what a divorce and a legitimation is. A divorce is a proceeding for people that are married. Now, in that divorce, you're going to, things are divided up, such as the house, the cars, the debt, the assets, anything can be divided up. What I've found in most cases is, with the exception of very high income people, the main sticking point in any divorce tends to be the children. If you're living in an apartment and you've got a few things, there's not a whole heck of a lot to fight over. You're not going to fight over silverware, I certainly hope. So divorce tends to be mostly child centered. Even a house that's worth $100,000, it's got a $50,000 mortgage on it. Both sides shouldn't be paying $75,000 to an attorney to fight over that. That's ridiculous. So legitimation is the process for unmarried people, specifically fathers, to be able to have legal rights to their children. In Georgia, you are not, and in many states really, you are not automatically considered the legal father if you have a child out of wedlock. You have to file what's called a petition for legitimation in the Superior Court. That is not the same as the little form that they'll run and bring you called an acknowledgement of paternity in the hospital. The acknowledgement of paternity does two things really. One, it allows the child to take your last name, but it doesn't give you legal rights to that child. A lot of people think that if I'm on the birth certificate, I have legal rights to my child. There was a very short period of time, but because there was a lot of paternity fraud going on in the state, they've changed that. So now a child born out of wedlock must go through a legitimation process. And that's done only through Superior Court. A lot of people think that, well, I'm paying child support for my child, that means I'm the legal father, right? No, that means you are the biological father and you're legally required to pay child support. It doesn't give you any rights to do anything with the child. It doesn't even give you the ability to visit with them if the mother or the custodial parent doesn't want you to. Now, if you haven't legitimized the child, the custodial parent is in most cases the mother, unless defects has come in and changed custody for some reason, maybe to grandma or somebody. So it's a very similar process. Divorce and legitimation are very similar processes. It's just the matter of one is for married people, the other one is for unmarried people. Divorce can cover a little bit more than legitimation can. In a legitimation proceeding, they can't award spousal support because there was no spouse. They're not going to award the house because there wasn't a house that you guys there wasn't marital property or marital debts. But other than that, for the child advocacy or the child custody, it is pretty much what it is. So let's start out with understanding what is in the child's best interest. The child's best interests are almost always served best by equal or almost equal time with each parent after a breakup. Now, the child's best interest is generally to grow up in a two-parent household with both mom and dad living under the same roof for the next 18 years. But we're in the times we're in, that doesn't always happen. So we have to figure out what the best way is for you to be able to get this information, or to parent the children in the best possible way after divorce. So children that are growing up without both parents in their lives, they're twice as likely to drop out of high school, 4 times as likely to have emotional or behavioral issues, 7 times as likely to be a teen parent. 63, they account for 63% of youth suicides, 85% of prisoners, and 75% of rehab patients. It's very, very, very imperative for children to have both parents growing up. And the reason is very simple. You and your ex do not parent the same way. Okay. They need a male figure, a father who is able to show them things that the male excels at, and they need the things that mother excels at as well. I can tell you that me and my ex do not parent the same way. Me and my female friends parent very differently. Me and my male friends tend to parent very similarly. It's just a matter of what our nature is. And the children need both of those things. It's kind of a balancing act. So you learn certain things from mom, you learn certain things from dad. Girls learn different things from dad than boys do. And boys learn different things from mom than girls do. So it's very imperative for that combination to be able to work in tandem. Um, let's see. I'm going to go through some of these questions here real quick, and then we will come back. I've got some more stuff, obviously, but I do want to get to everybody's questions because I see people starting to chime in, and I appreciate that. Um, how long does a parent have to abandon their child to file for abandonment warrant? Generally, abandonment is a child support issue, but it's normally something that you have to provide something at least once every 30 days. But that would be a very case specific question. If I provide you a McDonald's meal once every 30 days, that may still constitute abandonment. I'm on my son's birth certificate. The son's mother won't let me see him, and I will be considered an abandoned father. Um, well, they cannot charge you with abandonment if you're making an attempt. It's hard to charge somebody with abandonment if you're making an attempt, but you need to make sure that you're showing that you're making attempts. Abandonment, like I said, tends to be a child support issue. If you are paying something towards child support, you probably won't have that issue either. With that being said, though, you need to go ahead and get that child legitimated. There's some forms at legal aid you can get. Now, they're not going to be a ton of help. I'm not going to rose color this. It's very hard to get attorneys to help in this type of situation. For if you don't have a lot of money. Of course, if you have money, you can get all the help you can imagine. Um, so you should get the child legitimated. That will get you a parenting plan. And that way you can see the child, you can spend time with the child, you can parent the child, you can raise the child, you can teach the child, you can do all the things that you should be able to do as a father. All right. Let's see. Will the judge honor my child's father's request for a last name change? We are and never were married and going through the courts currently. He is requesting our child's last name change from my last name to his. Um, Maybe. I don't want to give you an answer on that because it depends on the judge and the age of the child. Most cases, children do carry their father's last name after a legitimation. If the judge that you have may have different views on that. They may say that if the child's carried your last name for a certain period of time, then it's already created an identity. Some will say that they want to hyphenate it or something of that nature. Generally speaking, if somebody is filing a petition for legitimation and they didn't squeal in on two wheels when the child was 16, a judge is going to order some type of a name change. But again, that's not guaranteed. The code says the judge may, which means they're allowed to, they're not required to. It makes it really hard for people to know what a judge is going to do. If you have an attorney, your attorney might be able to give you more insight into that specific judge. Because again, if you know who I am, you know me, you'll know kind of how I do things. But that doesn't mean that everybody does things the way that I do it. So a good attorney might be able to give you a better insight as to your judge. But in most cases, if somebody is trying to legitimate their child, then there will be some type of a last name change. How do I go about getting visitation rights to see my children? Well, that's going to depend a little bit on what your situation is. If you, I just need a little bit more detail. Again, normally this is something where it is dealt with through superior court in some kind of a modification of custody, legitimation, or divorce. Let's see. What if they're not paying child support and the child is legitimized? That would be a contempt issue if they're ordered to pay child support. If they're not ordered to pay child support, then that would be dependent upon what the judge's order was. I'm in the process of waiting for child support for my son. They claim they were waiting for a court date. They haven't said that it's been served yet. What would be the reason we are waiting for a court date if he hasn't been served yet? Well, if he hasn't been served, you probably aren't going to have a court date because you have to serve somebody because a child support application is essentially like a lawsuit, and that person has to get due process. In other words, they have to know that you're suing them. I can't just sue you without letting you know, and that's what the point of service is. With that being said, especially with COVID, a lot of things are moving really slowly. If you're going through a child support office, that tends to move even slower yet, just because it's a free service that you're receiving and you're getting what you pay for. Let's see. The state gets federal money for putting fathers on child support. That's absolutely correct. There's a whole bunch of money that's allocated for them collecting child support. Thank you for everything you do. You're very welcome. Will House Bill 1140 be retro as well as from prior cases if it becomes law? Well, we haven't gotten to talk about House Bill 1140 yet. I'll briefly explain what it is since you've asked. House Bill 1140 was last year's shared parenting bill in the state of Georgia. We introduced it on in the House floor on March 9th. I think on March 13th, the Capitol shut down because of coronavirus. So our bill was just kind of left into a committee. Now, I had worked something out to where we had a committee hearing on it, even though the session had ended. We're going to be reintroducing the bill, so it won't be House Bill 1140 anymore. We're going to make a couple little small changes to it. The bulk of it is still the same. We're just trying to clarify a couple of little words here and there. But I guess the ultimate question that you're asking, it won't apply to cases that there's already an order, but you can file a petition for a modification of your current case. So once the governor signs it into law, will you automatically have 50-50 time? No, you will not. You'll have to file a petition for legitimation because we have to determine how that 50-50 split's going to occur. But you will be able to modify your current order as it stands right now, and I'm not likely to want to back down on changing that to where it only applies to new divorces or something. That's just not logical. Just go forward and take care of your child. Stop with the courts. They only want federal grant money. Yeah, I mean, there's a lot of fighting that goes on. Unfortunately, the courts kind of make it to where we have to use them. I don't know. That must be a response from something above. In the state of Georgia, what age can a child choose who to live with? So right now, they have to consider the child's wishes between 11 and 14. It's presumptive after 14. Here's a little bit of insight, though. In what we're trying to do, we're trying to default this to 50-50. That means we don't necessarily want to have children making the decisions. They still can have a little bit of input, but we're not going to make these hard rules because a 13-year-old, my 13-year-old might be more mature than your 15-year-old, right? So it doesn't, it's not always that hard line for age has always seemed a little bit silly to me. But as of right now, 11 to 13, the judge has to listen to them, although he can disregard everything they say. And after 14, they're generally granted whatever they want, although I've seen some cases. I've seen some cases change. I have an attorney who's willing to help, costing me $4,000. Be careful. We're going to get into selection of attorneys in a little bit. $4,000 sounds like a pretty low price. A lot of times that's just a retainer. If they're billing out at $300 an hour, though, that's only about 13 hours of work. If it's a contested matter, a lot of times that happens. Let's see. My son lived with me for the last 5 years. I have a court order on him where we share physical custody. My son moved in with us about 3 years ago. Never provided rent bills. Recently, she left but took the child and went to the state for help, and now I'm not able to see our son, nor is she letting me talk with him. I have an attorney. We filed for primary custody, not contempt. Well, if you have a court order, you should have filed, I would have filed for both. That's both a contempt issue and a issue in which custody should be changed. So yeah, I think that probably both of those would be a good thing to do. I'm going to go through some tips for preparing for this. I'm glad to see you have an attorney. I'm gonna go over attorney selections and things that you can do to help your attorney in a minute. Yeah, 11 if the child, we're talking about the age at which a child can decide. I don't know very many judges that are letting 11-year-olds choose who they want to live with right now. Is there a standard visitation for dads with every other weekend for the summertime? How many weeks? Okay, so that is dependent upon the judge. And that's kind of the problem that we keep running into, right? Is if I take the same case to 5 different judges, your parenting time is going to look very, very differently from all 5 judges. So what I have seen most commonly in Georgia is that during the summer times, the every other weekend parent tends to get a week on, week off. That's a little bit better than it used to be. When I was a kid, my dad got 2 weeks out of the summer, but they tend to go every other week now, most cases. Although sometimes I have seen them give the non-custodial a little bit more time in the summertime to kind of make up for the time that they missed during the school year. So it's going to be dependent upon the judge. It also may depend on how far apart you guys live. I mean, if we have to put the kid on an airplane back and forth, it might make sense to do 2 weeks on, 2 weeks off, or something of that nature. All right, that's kind of is Title 4D. Title 4D is an incentive program that pays the states for child support collection. I just got that back. Can I get my local house rep in contact with y'all so y'all can have them on y'all's case? Yes, 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 yes. Please, everybody, contact your state representative. I can tell you that my custody case cost me about $50,000. I get a little tiny bit more time than what is standard in the courtroom, which I appear, but that's $50,000 that I spent, not including what my children's mother spent. Um, that could have gone, assuming that she paid the same amount of money, that's $100,000 that could have gone towards my kid's college fund, right? So, or to start a business or whatever may they may want to do. My 13-year-old daughter is getting up to the point that she's going to need that, and quite frankly, we spend it all on attorneys. So we need to get this changed to where people aren't fighting and bickering. It's an emotional process, but we definitely need to do that. I think the changes in legislation will help. So if you have a state House representative, well, everybody has a House representative and a state senator. Now, I'd like you to call your state level representatives and your state level senators, not the federal ones. So I'm not asking you to call Jon Ossoff and Raphael Warnock. I'm asking you to call your local person, and I'm not going to go through all the senators because there's a lot. But there's a state level and then there's the federal level. So please keep that in mind. We're working with the state representatives and the state senators. I'm not doing a lot of work with the federal representatives and the federal senators. Mark Ludwig at Americans for Equal Shared Parenting primarily handles that. I will help him out. He knows that I'll help him out. I'll be there whenever he needs me to be. But I'm not that's not our primary focus, right? So ours is on the state level. So please, if you can get with your state representatives and state senators, they will be helpful. Um, let's see. Thanks, Charles, for all the rest of the replies. See you at the pool. Yes, yes, yes. That this is my daughter's swim coach. So yes, we will see you at the pool. Um, if your children are legitimized and you're not paying child support, instead you're challenging for full custody. Yeah, there shouldn't be challenges for full custody in very many cases. We should be challenging for 50-50. That's what's in the child's best interest. Their primary custody is almost always against the child's best interest. Yes, these are very stressful events. We definitely need to do that. Um, why are trials by jury not allowed in family court? Well, um, I have my own opinions on that. The canned answer that I'm going to give is that they don't think that juries are the best. Juries are going to be more susceptible to attorneys' games and whatnot like that instead of looking at the facts. I don't know that I necessarily agree with that, but it's the way that the law is written. What does the father need to do in order to see his daughter if the mother does not even like his wife? That wrong, keeping the baby away from him. Okay, so um, it depends. If you have a parenting time order, so a custody order, a visitation order, whatever you want to call it, and she's not abiding by that, then you need to file a petition for contempt in Superior Court and ask that the judge enforce the order. And he can do that through all kinds of things. He can make her pay your attorney's fees, which is one of the more common ways, as long as you have clean hands, and just by marrying somebody that's not making you not have clean hands. If you don't have a custody order, then you need to file either the petition for legitimation or try to get a custody order in place so that there's some order from a court that says what you get and what you don't get. Um, My husband has a criminal background. Can he get full custody? Potentially. I don't know what his criminal background is. Um, I mean, it's a choice that we make when we choose a partner. There's lots of different crimes out there. Some have a worse thing than others. I mean, if it's for hurting a child, potentially not. But again, I would strongly encourage you to try to work out a 50-50 plan. What if you're challenging but would be happy with 50-50? Yeah, I mean, ideally in a situation, and if all goes well beginning in July, you will have to come in saying, I want 50-50. Otherwise, you could actually be the parent that gets a little bit less than 50-50. So right now, a lot of attorneys will tell you, shoot for the moon and the stars, and then we'll settle somewhere in the middle, and we'll just duke it out in the courtroom. And once it's a terrible system right now. If you can get it through mediation is also a great opportunity. And most courts actually require it now because most judges that I've found don't really want to get involved in this. In a jury, which I thought was allowed, I always heard the judge can only make a judgment with custody and the jury can make. Yes, but it has to comply with the law. So, if you're self-employed, a lot of times they'll try to say, oh, you're not claiming all your income on your taxes or something of that nature. They can make determinations on how much money you make, and maybe some of the deviations. But the child support guidelines are laid out pretty clear. How do you deal with visitation during COVID when a parent doesn't want to take safety precautions, attends overcrowding events, parties, travels leisurely by plane? Will I be frowned upon for discontinuing visitation due to the father exposing the child? He contracted COVID and caused both child and I have to quarantine, no court order yet. Yes, that would be frowned upon in most courts. We're going to parent differently. Men and women, and even I suppose all kinds of people are going to take different seriousness lists with this. I think that you'll look like you're not being much of a co-parent if you're withholding visitation. I would strongly encourage, you may want to talk to them. We'll kind of get into exes talking in a little bit, but you may want to kind of talk to them and maybe come up with something. But yeah, that would be frowned upon in most courts. And again, it's going to depend on the judge, unfortunately. Mediator is great and way cheaper. Yes, mediation is a much better option for most people, at least financially speaking. Preparing for a trial is exhausting. And attorneys are charging generally close to $300 an hour for it. A mediator normally charges $100 an hour, and the parties split that. So that's $50 an hour, maybe 75 depending on the county, but that's a whole lot better. And a lot of times they'll try to work you towards that. If one parent makes more than the other, how does child support through the court determine the financial support determination? Well, regardless of who makes the most money, there's a calculation for child support. So I'm going to kind of move on from the comment section for a little bit, and then I'll kind of come back. So keep putting any questions you have. You guys are having a lot of really good questions. This is my first time using this platform, so I'm pretty impressed with it so far. And thank you guys for chiming in, because it does make it a little bit easier rather than just standing here talking to myself. So I would like to kind of talk about attorneys, okay? Now, like I said, attorneys, the average is around $300 an hour. You may find some that are a little bit cheaper than that, and there are certainly some that are a lot more expensive than that. You want your attorney to do kind of as little as possible because it's very expensive, right? So you have an attorney, and attorneys have a very important role to play, right? So they know how to cross the T's and dot the I's and get things in front. They know what makes the judge tick. The difference between a good lawyer and a great lawyer is a great lawyer knows or a good lawyer knows the law, and a great lawyer knows the judge. And that is especially important in family law, because the judge has a tremendous amount of discretion in family law cases. And that's one of the reasons, and I know that a lot of times we want to do our cases on our own. Some people have had very good success with that. I'm not trying to discourage anybody from that, certainly. But if you have a local attorney that at least knows what this particular judge, weighs heavier on, that attorney might be able to help you a little bit. Now, one thing is oftentimes we need an attorney, or at least a support person, who's the polar opposite of us almost, right? So if you are a very aggressive person, you don't want an aggressive attorney, because the two of you guys together will just look like you're just a bunch of angry people. That doesn't look good in front of a judge, right? If you're kind of very reserved and laid back, you might want the more aggressive person, because they complement each other, right? So for those of you who have been following my page for a long time, you know that I work really closely with Natalia, and we're similar and different all at the same time. We have different strengths, right? And you and your attorney are going to have different strengths. You want you and your attorney to have different strengths, because if you guys both have the same strengths and the same weaknesses, that doesn't look good, because it leaves a big hole of weakness, right? So you want to be the yin and the yang, and work together. But your attorney shouldn't be making your case for you, right? Your attorney needs to have you make the case to them, and then they package it nice and pretty, and submit it to the court. I find a lot of times, because of the difference in personalities, sometimes it's better for a man to have a female attorney and a woman to have a male attorney. And again, it's just because of the different personalities, the same difference in personalities that causes us to need a mother and a father for the child. So that's definitely something that you want to consider. I'm not saying that if you're a man, you should never get a male attorney, or if you're a woman, you should never get a female attorney. There are people on the range of spectrums. But there are a lot of attorneys out there. And so if you're going to use an attorney, definitely make sure it's somebody that their strengths are your weaknesses, and your weaknesses are their strengths. Just so that you have a better opportunity. For some people, you need that person that's going to shoot you down every now and again. I know it sounds a little bit crazy, but we just have to. Sometimes we look through our own eyes with rose-colored glasses, right? So you need to start bringing the attorney evidence, right? You're going to need to show pictures. You're going to need to show report cards. Be prepared. One thing that a lot of people don't do, and I think that it is something that we should all do, especially because we're spending all this money, $20,000, $30,000, $40,000 for this case, and a lot of people say, well, I don't have time, I got to go to work or whatever. Take a day, find out when the judge that you have has their family law calendar. It's really easy right now because in a lot of counties, they're doing this stuff through Zoom. And so you can actually sit and watch how the judge interacts. Um, so, you can see when mom in this other case that has nothing to do with you said this, did the judge kind of look like this woman here? Or did he, oh, wow, yeah, that's a good point. You want to be able to capitalize on that. So that's getting you to the point that you also know the judge, just like I said with the attorney. I don't recommend getting an attorney that's halfway across the state. They might be a little bit cheaper, especially like around here in Atlanta. Office rent is high and cost of living is high, and out in middle Georgia, it might be a little bit cheaper because he doesn't have as much expense going on. But if I'm in Fulton County, I want a Fulton County attorney. If I'm in Henry County, I want a Henry County attorney. If I'm in Chatham County, I want a Chatham County attorney. If I'm going to bring an attorney from Atlanta down to Savannah, that attorney doesn't know that judge at all. And especially once you get outside the city, if you bring in an attorney that's like from the city, they look at them like, oh, this little city slicker here. It's the same thing when bringing a country attorney into Fulton County. It's just doesn't work out very well. So even if it's a little bit cheaper, or you have a friend or somebody that's going to work with you, I would strongly encourage finding an attorney that's familiar. But the way that you can also do this is watching these court proceedings. And I know they're terrible to watch. It's absolutely the worst thing in the world to sit and watch people fight over their children, fighting over temporary protective orders and all kinds of stuff. It's aggravating. But watch two or three of them. I mean, it doesn't hurt to watch them and learn what the judges are doing, because everybody should know what their judges got going on. Helping your attorney get prepared. One of the things that I think people have an issue with is when you're helping your attorney get prepared, he knows the law and you don't. And you're running on emotion and he's running on the law, right? Or he's running on how the judge acts. If you have to know what evidence you can bring in. You can bring in pictures. You cannot bring in affidavits. Affidavits are useless in almost every situation because they're hearsay. Hearsay means that if somebody brings an affidavit towards you, at you, I can't cross-examine the affidavit, right? So I can't find out, well, how do you know this? I can't give follow-up questions. So generally speaking, you have to have in-person witnesses to be able to testify. An affidavit works okay if you're just putting it into the pleading to kind of create a prima facie case, but you should be prepared to have that witness testify on your behalf in person, or again, via Zoom is now kind of the going way. Now that can be a good thing. You can actually call in expert witnesses from other states that can appear via Zoom, right? You could be watching me from China, and I'm not telling you that any of this applies to custody laws in China, but you could bring in anybody from anywhere in the world. So that might be a benefit. Normally that would be cost prohibitive. If you brought in a really good expert to an in-person hearing, you might be looking at $50,000 to $100,000 to fly them in, put them up in a hotel, pay their daily rate, all this, that, and the third. So you may be able to bring in some expert witnesses, especially for those of you who are trying to get 50-50 custody. There's some fantastic witnesses. If you go back and watch our committee hearing that we had last month, you'll see a lot of really good witnesses. Not all of those witnesses were here in Georgia. Dr. Warren Farrell had Zoomed in for us from California. Emma Johnson had zoomed in from New York. Now we did have most of our people were local, but we did want to have the best witnesses possible that have studied child custody and child parenting arrangements and whatnot, to be able to explain this stuff to our legislators. One thing that I want everybody to understand, talking about your ex to your children is never okay. It will always be used in court against you, as well it should be. I know it's aggravating. My ex intentionally aggravates me, but I can't go and tell my children that, because then it looks like it looks really bad. It messes with their psyche. If you have ever told your child that mommy's a piece of crap or daddy's a loser or whatever it is, don't do that. Stop that now. That will cost you custody. And it will make your children resent you as they get older. You'll win the battle maybe, but you'll lose the war. Don't do that. Because here's the truth of the matter. You made a decision to make this child with this other person, right? If daddy is such a bad person or mommy is such a bad person, what does that say about you for making that child with them? And that's an uncomfortable conversation for a lot of people. I dislike my ex. Yes, I do. But I won't say that to my children. Okay. At the end of the day, that's their mother. They should love her as much as they love me. And they should never know of her as anything worse, anything bad. Eventually, they'll catch on to certain things, and they may not like those certain things either. But you can't destroy the child's relationship with the other parent. And in fact, that again could cost you custody, and in some cases could cost you jail time, depending on the judge. And talking to the ex. So some people are able to really co-parent really well. I know my friend Linda Steele, she does a lot with co-parenting. She will, if she's going to another state on vacation, she'll invite her ex to come, and he's got to pay his own way. He's got to get his own hotel room. He's got to pay for his own event tickets, all that kind of stuff. But if she's having a family event, she'll invite him to come along. If that works for you, that is a fantastic scenario for your children. A lot of us, though, we don't have that. So we have to, what's called parallel parent, right? So at my house, I have my rules. At mom's house, she has her rules. The children do learn those rules. They know whose buttons they can push, how to push those buttons, and this, that, and the third. And we kind of go along. We are both working for the best interests of our children. But at the end of the day, what we're ended up doing is making sure that the girls have two tracks going in the same direction. So I don't involve myself with what she does, and she doesn't involve herself with what I do. So what we can kind of go back to the question about the travel and this, that, and the best way to do that is to say, as long as the child isn't being hurt, injured, physically hurt, whatever the other parent does during their parenting time is none of your business. What you do during your parenting time is none of their business. I mean, if you're getting a call from the hospital saying that the child's busted their head open and this is an ongoing thing, maybe some issues, right? But just kind of parallel parent and take yourself out of that situation. I think a lot of times as people, we want to kind of be involved in the situation. We want to control every aspect of our kids' lives. We just simply can't do that. All I can do is what I can do while my children are with me. I will try to get as much time with them as I possibly can to put them in down the path that I want them to go. I can't control mom. I will drive myself crazy trying to, and I'll just make myself angry. What she does at her house is completely up to her. Um, and I know that we get a lot of people. Well, I don't know her new husband. You don't need to. If you can have that relationship, that's good. But if not, running out, going to court saying, "Hey, I don't know the new husband." You get her for getting a new husband. She's allowed to have a new husband. You guys got divorced, right? Or maybe you weren't married. If you didn't marry her, then she's allowed to go and marry someone else. And I use a lot of pronouns here. Please understand that I mean men and women. The father can have a new wife. I think that was one of the questions we talked about. You don't have to like that new wife. In fact, most of the time, that's the way that it works. Especially with having a mom and a stepmom. A lot of times, the mom doesn't like the stepmom. What happens at that house stays at that house. What happens at your house stays at your house. It'll keep you a lot more sane if you just check out from that aspect. But when you're talking to your ex, remember that in 2020, we're all using a cell phone. All the phone calls are recorded. If you're doing a text message, it's definitely recorded. So I've seen a lot of cases where there's been issues with the back and forth that happens either on the phone or via text message or via email, where everybody gets in a emotionally fueled back and forth. Don't do that, okay? One of the great parts about text messaging, and they have apps like the My Family app, and I'm not really familiar with those, but they're basically a text messaging app that's designed for co-parenting or parallel parenting in most cases. Assume that the judge is going to see everything that you send. If it doesn't make it better, it makes it worse. So if you say, okay, I get it. We don't want to talk bad about the other parent, but I'm going to go ahead and talk bad to the other parent. I'm going to get into an argument. I'm going to kick and scream and yell because she was 15 minutes late picking them up, or I'm going to act crazy because whatever she was 20 minutes late on a phone call or whatever the case may be. That makes you look crazy. If you can have somebody, and again, I strongly encourage this somebody to be somebody of the opposite sex in most cases, somebody that can read through it or at least is emotionally removed from it, because we're all emotional creatures. Men tend to either come across, if they're acting out of emotion, is very weak or very angry. Women come across a little bit differently when they do it, but they will oftentimes come across as a little bit crazy when they do it. So instead of emotionally responding, 10 seconds, I just got a text message, I need to respond in 10 seconds. No, you don't. You can wait 30 minutes. Calm down. Let your nerves calm down. If you have been drinking, you might want to wait until you sober up to respond. Anything beyond an okay or something like that, you need to think about it. Text messages are one of the most commonly used pieces of evidence in court right now. And I've seen a lot of moms and dads lose cases because of the way that their text messages read. So please remember that. Phone calls. We're a one-party state in Georgia, as is most of the country, which means that if you're a party to the conversation, you are legally allowed to record it without telling anybody. I can't record a call between my daughter and my ex-wife because I'm not a party to that. Please don't get in trouble for eavesdropping. That's a problem. And that's a criminal offense. But if I'm a party to the call, I can always record it. And so assume that everybody's always recording and assume that the judge is going to be watching this and assume that they're going to consider the other person completely sane. Look at what your text messages say and only your text messages, because when they introduce them into evidence, they're only going to read what you put. This is somebody that you've had a relationship with. They know how to push your buttons in just the right way to make it to where you're going to come across as either angry, crazy, or some other way that's going to benefit them. And in fact, a lot of their attorneys will tell them to go ahead and just poke the bear just a little bit, because you know how to poke the bear better than anybody. And the other parent is going to look really bad, and that's going to help our custody case. Let's kind of go down here for the thing. So if you already have a case and this bill passes, you'll need to file again. Unfortunately, you would have to file a modification. We can't really go back and change existing orders, because what would a 50-50 in your situation look like? A judge has to decide that. So once the bill passes, which we hope will be this year, please don't just automatically unilaterally change your parenting plan. In an ideal situation, we are trying to get this set up to where it encourages strongly parents to settle this out of court. So it may be able to be ran through mediation or something of that nature. Maybe have an attorney that sits down and creates parenting plans. Our court's allowing this right now. I don't know what this is. I'm sorry. I remember you asked a previous question, but I don't remember what it was. I guess if you would expand upon it. I know you asked about the COVID thing, but that might be what it was. But if you put in another comment and just be a little more specific, I'll get right back to you. Parent taking care of their children, meeting their needs and wants already, why the courts put that parent on child support? Because the state makes money on it. What kind of advice do you have for me if I'm trying to get my kids and the defect states that I don't have a case plan for me and I need to get pointed in the right direction, and if possible, a number I could talk to someone? So despite what we're doing today, we generally do not help with the individual cases. With the exception, we do Rule 22s to help document the case. A lot of times judges act a little bit better when they're on camera. Rule 22 is basically something that we file that we ask the court to allow us to come into the courtroom and record the proceedings. They most of the time get approved, and even if they don't, we're generally there to watch. Other than that, that's really the only individualized things we do. I don't understand how they couldn't not have a case plan for you. That's their job. If this is a defects case, they need to come up with one. So I'm not really sure why they're not doing that. It may be something that if you can find an attorney in the area that knows the DFAC system, they might be able to help you with that. Um, but generally speaking, the DFACS has to come up with some kind of a plan. Yeah, so Scott, I'll tell you, I work um my entire job here is it has been to help people do certain things pro se. The problem with family law and pro se tends to be that you're operating on emotion. And the unfortunate thing is even in a lot of the very simple cases, people will mess them up themselves. So I will tell you that I've spent my entire career has been making sure that people are able to help themselves pro se. In fact, my business helps people pro se, the business that I operate personally to pay my bills every month. I don't, and I have gone toe to toe with the Bar Association on various different things. I've gone toe to toe with the federal government over various different things. In fact, if you do some research on me, you'll find where I have filed all kinds of pleadings against the U.S. government for wanting people to have attorneys instead of just getting some help. Um, that's not something that I'm necessarily a supporter of the bar, but right now, people, because of the way that the rules are and because they're so loosely interpreted, in an ideal situation, again, we're going to 50-50 custody, which gets rid of that situation and sends it all to mediation, really. Um, Muhammad says, document everything. Keep a custody calendar, kids' medical records, kids' grades, performance, behavior, pictures, videos. Keep backups of records, pictures, and documents in the cloud. Yes, that's a fantastic point, Muhammad. Um, Also, you're going to want to make sure that they're in an organized fashion. You need to bring them a timeline. Bring your attorney a timeline and sit down. Take a day off work if you have to. Right? We don't want to take away from the limited time that you may have with your children, but you may need to sit down and go through it, and everything has to be as quick as possible because remember they're charging you $300 an hour for it. So make sure that everything is in a good order. You need to be having conferences with your attorney. If your attorney's not willing to sit down and meet with you and explain what's going on every couple of months or so in your case, that's a problem. Just 1 hour where you kind of bring them up to speed on everything, see what they think. They'll probably give you some pointers there. I'm a big proponent of keeping in touch with your attorneys. If your attorneys aren't communicating with you, that's a problem. That's probably not the attorney for you. Uh, yeah, record the phone calls. It's keep in mind that they're probably recording you as well. Do not record your kids' phone calls because you're not a party to that conversation. You will get in trouble. Um, yeah, I like text and email as well, Mohammed. I probably can count on one hand the number of times that I've spoken to my ex-wife, in the last year without it being a text message or something like that. Um, if the phone rings and it has her name on the caller ID, my heart jumps a couple beats because she doesn't call me and I don't call her. Uh, so yeah, I'm worried about the children if she's actually calling me. Text messages are great though because you are able to take that time and not respond out of anger or frustration or emotion. whatever your emotion is. The emotions tend to cause problems. You got so much documented. How do I ensure the guardian and review it? They probably won't. You need to figure out what is the most important stuff and put it in something to where you can show the most important stuff. A guardian ad litem may review it all because they're billing you. So they may, depending on what their caseload looks like, want to run up fees. So they'll look at everything. A judge will never look at a whole bunch of documentation if you have a lot of documentation. So the main thing is to get the most important stuff, make sure that it's admissible, and make sure that it tells the story. But you don't have to have thousands and thousands of pages of documents. Nobody's going to read that. By the time they get partway through, they're completely tuned out, and then they may miss the important thing. So that would be something that I would that's kind of the way that I would tell you, is just figure out what the most important stuff is. Caught in a recorded phone call brainwashing my daughter. The GAL warned it could be that she could be arrested. I generally, brainwashing is not an arrestable offense, although you recording a phone call between your daughter and her mother could be. We still do have a First Amendment, so technically it'd be very hard to arrest somebody for brainwashing if it's just speech. Safe homes or women's shelters, can they advise a parent not to let a child see or communicate with the other parent? Generally speaking, when safe homes or women's shelters are involved, there's a temporary protective order that's entered. If there's a temporary protective order, yes, they can do that. They're one of the few groups that are able, as non-attorneys, to assist, basically give legal advice. Attorneys tend to have to be the ones to give legal advice, which is why I'm not able to necessarily help with very many individualized situations. But generally speaking, if there's a temporary protective order and the order says you can't contact them, then I suppose that they can do that. That if there's not a temporary protective order and they're advising that, the person that they're advising may have a cause of action, because the person they're advising could be held either civilly or criminally liable for that. So that's my answer to that. Keep your email and text messages short and concise and strictly about the children. Exactly. It doesn't do any good to tell your ex that they're a terrible mother or a terrible father. What did you accomplish by that? Other than making yourself look angry. So yeah, short, sweet, to the point. And you know, even if you have a good relationship or a quasi good relationship, sometimes that helps. Sit in the courtroom. Absolutely. Courtrooms are always public venues. You'll learn a lot. Again, by the time you're done with it, you're never going to want to set foot in a courtroom. I've come to the conclusion that would be a much better way to do pre-marriage counseling, is make them do it. Cornelius, a safety plan. Yeah, if DFACS is supposed to be doing the safety plans. If they're not doing that, then go to their supervisor. You can go all the way up to the governor's office if they're not issuing a safety plan in the way that they're supposed to. Are courts currently having courtroom proceedings to sit in and hear cases with COVID? It depends on the county. They are having court cases. If you call the clerk, they'll let you know whether or not they're via Zoom. So I don't know where you live. In Metro Atlanta, almost everybody is on Zoom right now. Once you go out a little bit more rural areas, they're still having some in-person proceedings depending on where you live. If you call the clerk and ask them, they will give you Zoom credentials so that you can go in there and actually just view it online. COVID, for all of the bad things that have occurred with it, have made doing this a lot easier. Um, the judge won't have time to go over, but the GAO will. They may or may not, Mohammed. It just depends on their workload. I'm going to put this up here. There are no cameras in the courtroom. You are correct, Scott. One of the things that we found very, very good, and it's unique to Georgia. Not every state has this, but we're able to file a motion to allow cameras in there. So we can, on behalf of our organization, come in there and say, Your Honor, we're recording these proceedings. We do a motion 24 to 48 hours ahead of time. We put all the attorneys on notice. No attorneys don't like it. Attorneys that are doing questionable behavior definitely don't like it, as our judges that are doing questionable behavior don't like it, but it's effective. We do expect judges, attorneys, guardians, and all parties to act in the child's best interest or children's best interest. So what is the guardian ad litem looking for? So a guardian ad litem, their first thing is to look out and basically make a recommendation to the judge. Judges don't have to go with the guardian ad litem's recommendation. They do more times than not, though. So the guardian ad litem may look at what mom and dad's living situation is. They may look into their financial records. They may look into who's going to school. They may interview the child to make sure that there's no issues with abuse or something of that nature. If they're doing their job properly, and we can kind of talk about what it really takes to be a guardian ad litem, which isn't much. They should be able to like play with the kid and interact with them in that way so that the child doesn't really realize that they're being grilled, especially at a young age. Who's got the most stability? Who has the better school district? Who has, if mom has people coming in and out of the house, that might be something that they're looking at. If dad is at work all the time, they might look at that. So they're going to look at work schedules. They're going to look at living situation. They should be looking at everything. So that's kind of what they're looking for. So they should be able to look at any evidence really that a judge would be able to look at. They're probably going to look at more because they're billing you by the hour. So they want it to take a little bit longer. If they've got a lot of cases, though, they may try to take shortcuts. There's some issues with that. How often does this group meet? Well, this is the first time that I've done this. If you guys are finding value in it, let me know. We might sit and do a few more of these. I'd love to have my partner Natalia here because she does give something that I I tend to, uh, she fills in the gaps that I don't have. Um, what if the guardian has not talked to the child and makes a recommendation after not reviewing the case in about a year? Yeah, that's a problem that I see with a lot of guardians. Their billing is terrible in a lot of cases. They'll say that they had sent I mean, I've seen it where they sent 3 attorneys to a school to talk to a kid, and it's like, why would you do that? And then I've seen other ones that don't do anything. They kind of sit on their hands. So you can object to the guardian's report. I know that I did that when I was going through my issue. It was disallowed, but I still had to pay close to $8,000 just to the guardian ad litem. It was maybe 10. So talked about the parallel parenting. Again, guys, this nothing that I've said here today is legal advice. I strongly would encourage you guys to, instead of trying to fight for full custody, sit down with the other parent and try to come up with a plan that maximizes both parents' parenting time. That might not be exactly 50-50 in your situation, but but maybe if you're working nights, maybe the night should go to the other parent instead of the babysitter. That kind of helps the child bond with both parents in a more well-grounded person. A lot of times you'll be able to tell somebody who grew up without their father, without their mother. And it's weird because it's a very different personality and dynamic than somebody who maybe their dad or their mom passed away. If they've just been taken out of their lives and they don't know why, even all the way up into adulthood, we have a lot of people that are doing that kind of the psychologists and psychiatrists, they're making a killing on this stuff. For those of you guys who are going through this, it is good to have some kind of a support group or support person, whether that be a psychologist, counselor, clergyman, sometimes significant other, just depending on how your relationship is. That other person, though, may have some emotional attachment into it, and that may be positive or negative, and there may be a little bit of both. If you can kind of get out of that inner circle and kind of have somebody that you can talk to, bounce things off of, have them read over text messages and kind of, somebody that's a very different personality temperament than you. So try to show that you're getting along. If you show that you're getting along, especially in the future, the parent that's the most likely to work and give the other parent maximum parenting time is going to be the parent that's going to be in the better position going forward. We're intentionally trying to make it to where the combative parent is the one that may have to pay the attorney's fees of the other one. Maybe the combative parent is the one that, oh, well, I'm not willing to do 50-50. I want 80% custody. Okay, well, if you're not willing to do 50-50, then we have to choose a primary parent. We're going to choose the other parent. So it's very hard because we're hurt. We have issues with this other person, and our children are the most important things in our lives, right? So we want to make sure that our children are well taken care of, that they're happy and healthy and all that kind of stuff. It's absolutely imperative that you maximize the other parent's parenting time. Because they will learn things. I don't mean maximize it as far as give them all the parenting time, but get it as close to equal as you possibly can. What might that look like? Okay, so for some people, they have what they call a 2-2-3 model, which means, and the genders can be switched around here. Mom gets Monday, Tuesday, dad gets Wednesday, Thursday, and then they alternate Friday, Saturday, and Sunday. That gives everybody kind of a 5 day, um, 5 days with the kid. Some do 1 week on, 1 week off. I don't recommend doing a switch out on Saturdays if at all possible, because you want that Saturday to be able to get up and do things with the kids. So if you do the switch out, maybe after school Friday, or the switch out before school on Monday, that tends to be the best way that one works out. If you're a little bit further away, some people do 2 weeks on, 2 weeks off. If the kids are school age and they're in a school that's not reachable by both parents, so if it's more than maybe 35, 50 miles, just depending, um, you may have to do something to where the parent that is gets the kids during school only gets 1 week in a month, and the other one gets most of the weekends, just because they're too far apart. So maybe we like to give mom second weekend a lot of times, uh, because it falls with Mother's Day. Um, so that might be an option. It may be an option where you go and one parent comes over, and maybe it's a 2 hour drive. But you make that 2 hour drive every Wednesday. You have dinner with the kids. You take them to a restaurant or something of that nature and spend a couple hours with them. If it's a 2 hour drive, that might be the best that you're going to be able to get. But get it something gets during the week, at least during the school week. On the weekends, you probably should be able to get some extra weekends if you can't get the school time. And for those of you who are the custodial in that, make sure that you encourage the relationship, that you ask that the other parents show up at the baseball practice or whatever your kid is into. Um, Last thing I want to talk to you guys about today, unless there's any other questions in here. We are working, we should have our new bill. It won't be House Bill 1140 anymore. That bill is officially dead. Um, we're going to be reintroducing a bill later this week into the legislature. Legislature theoretically should run until April. Based on everybody that I've talked to, though, it's probably going to go a little bit longer. There's 40 days of actual legislative session in Georgia, but there's days in between that there's not session going on. So normally it goes from January to April. It started yesterday. We have Representative Clark refiling the bill later on this week. We think that we're going to have the same set of sponsors plus a few more. Now, you won't be able to see all the sponsors on the website. Okay, we have a lot of sponsors on this bill. We have a lot of legislators that are working really hard. I know in our political climate, we often times have that legislators, they don't care about us, or they're not doing their job, not working hard. I can assure you, I have text messages and call logs in here from legislators at 10 o'clock, 11 o'clock, midnight. They are working hard. They only make $17,000 a year, guys. So they're working. You're getting some pretty good bang for your buck there. If you can donate to us, that does help us. We have some expenses that we have to cover when we're doing this lobbying. We're not paid, but we do have some expenses that we need to do. So if you can go to our website, GPKR, and there is at the upper right-hand corner, there will be a donate link. If you can donate a few bucks, that'll help us get this moving. Our goal is to make it to where $50,000 or $100,000 in attorney's fees is never heard of. Okay, that's not in a child's best interest in any situation. Um, children need a lot of things, but you to spend all your money on attorneys is not one of them. The other thing I'd ask all of you guys to do is call and let your legislators know that they should support shared parenting. We have some other things that we would like to get done here in Georgia legislatively. This is step one. Again, we don't have a lot of money coming into where we have a $200,000 lobbyist. You have me and Natalia who are not paid, and so we still have our jobs to do. So we can only push one bill at a time. We're working really hard for you to get these bills passed. We're working really hard for our children because I went through this as a child. I've gone through it now as a parent. I will be damned if my children go through it as a parent or my grandchildren go through it as a child. It's not fun. It's not enjoyable. Eventually, I'll probably do something with an adult child that will tell you, you will be able to explain how the system has impacted her and how 50-50 would have helped the situation. But the constant back and forth, even before a bill gets passed, I'm encouraging you guys to try to work something out with your other parent to try to get it as close to 50-50 as you possibly can. It makes the children happier. It'll make you happier. It's certainly better for your wallet. So there's a lot of things there that are benefits to getting this 50-50 bill passed. So that's all that I have for you guys tonight. We've gone for about an hour and a half. Let me check, make sure there's no other comments here. I don't see any. So we may do a few more of these here and there. If you have anybody that you know that may benefit from this, refer them to Georgia Parents for Kids' Rights. Even if they're not in Georgia, we want to help because this is all about the rights of children, and it's very, very important to try to benefit every child there is. The vast majority of the mass shooters that have come through the United States came from single family homes. We would really, really enjoy making sure that that doesn't happen to another child. So that's all that I have for now, and I greatly appreciate it. Bye.